Welcome to the Canadian Immigration Answers podcast. My name is Mark Holthe. I'm an immigration lawyer practicing in Alberta, Canada. Today's question relates to one of our most popular topics, express entry. As most people are aware now, express entry is a new way that the government is able to manage the influx of applications or people applying for permanent residence in Canada. Express entry is used as a management tool to control the number of applications that come into the immigration streams each year. And by doing so, they are able to keep processing times down, thus express entry. Processing is supposed to be done within 6 months of receipt of the application. Now, the question that has come up quite a bit lately is whether an LMIA, a labor market impact assessment, is actually needed in order to qualify and be drawn from the pool and given an invitation to apply. The government has consistently indicated that an individual does not need a labor market impact assessment necessarily to be drawn from the pool and given an invitation to apply. Now, as our dear government has done on a number of separate occasions, that answer is true and correct, but it's critical to understand what they're really saying. Now, a careful review of the immigration regulations that have been published in the Gazette on December the 1st suggest that individuals who wish to apply through the federal skilled worker or the federal skilled trade categories will, for all intents and purposes, need to have an LMIA in order to qualify. Individuals who are going through the Canada Experience class may not require an LMIA. Obviously, if you have one, it's good because you'll get the extra 600 points towards the maximum 1,200 points candidates can obtain through the new comprehensive ranking system. However, if a person has sufficient numbers of human capital points, they may be able to qualify without an LMIA. Now, this has been something that we have talked about over the last month considerably and recommended that people apply right away if they do not have an LMIA because there's a chance they could be drawn even without that supporting job offer if they get in the pool quickly. The government does not feel that there are large numbers of LMIA-based work permits that would be seeking permanent residence at this time, and so it's possible that individuals can get in on human capital alone. However, without getting too technical, if you are hoping to qualify under the Federal Skilled Worker Program or the Federal Skilled Trade Program, at the very onset, you have to meet the qualifications for those programs. In the case of federal skilled worker, you need to obtain at least a minimum of 67 points in order to qualify for that program. Well, if you're relying on arranged employment and that arranged offer of employment to give you an extra 15 points to reach your 67 points, you can only count those arranged offers if you have a labor market impact assessment. So basically, the government's saying that in the past, we allowed those on LMIA exempt work permits to also collect the points, the extra 15 points for an arranged offer of employment, regardless of whether they have an LMIA, as long as the company they were working for was willing to offer them an indeterminate offer of employment. And that usually came in the form of a letter for existing temporary foreign workers where the company that they worked for provided that letter of support. But that's not the case anymore. If you want to qualify under federal skilled worker or federal skilled trades, you pretty much need to have a labor market impact assessment. So the short answer is no, you do not need to have necessarily an LMIA to qualify and be granted an invitation to apply through express entry. But please be advised that if you don't have one, you need to get your application in immediately And I'd also want to bring up another factor that the government intends to place priority on certain types of applications over others. And so we envision that applicants under the federal skilled trades and then federal skilled worker category and then finally CEC, the Canada Experience class, the government will rank these programs in order of priority, and the FST will rank ahead of the FSW, and the CEC will come in a distant third. So if the government is looking to draw individuals from the pool, they can indicate that they're only drawing federal skilled trade this round, or they're only going to draw federal skilled worker. And because CEC is the easiest to qualify under, that program will always rank third when it comes to them pulling individuals and giving them invitations to apply. I'll also indicate that when you're applying for express entry, you will not be the one who chooses the program that you go through. It's actually the government. And so if you're engaging an authorized representative, a law firm or a lawyer, and they are submitting an application for you, they will have to go through the same wizard as you would through the online application process, which will, in essence, make the determination as to which category you will be going under. Now, obviously, as we work forward and get more familiar with the program, we'll be able to answer questions in a way, hopefully, that will try to steer people towards the program that we feel would be of the most benefit to them. However, ultimately, the government will decide which program you go through. So I hope that has answered in a pretty fulsome way the question that was asked. But it's going to be an interesting world to see how all of this express entry mania unfolds as people are scrambling to understand the program, to get their documentation ready, and to be ready to apply. If you have any questions that you would like to ask me and our law firm, Holthe Tillman LLP, please go to our website, ht-llp.com, and you can ask a question through our text entry system, or you can alternatively click on the right sidebar, the tab that says Ask an Immigration Question, and you can leave a voice message for us. We do our very best to collect all of these similar questions together and then podcast the answer as frequently as possible. So ask a question and we will endeavor to answer it. Finally, if you feel that you need more specific answers, you can contact our firm through our consultation section on our website and request a paid consult. We charge $100 for a 30-minute consult, and you will be able to speak with me. I look forward to our next podcast where we answer more immigration questions. Signing off.
Thank you for listening to the Canadian Immigration Podcast, your trusted source for information on Canadian law, policy, and practice.
If you would like to contribute a question for future podcasts or wish to set up a legal consultation with Mark, please visit www.ht-llp.com.